Yes! Hello, my beautiful friends. What an amazing day it is. And welcome back. Hopefully, we're coming in loud and clear to wherever it is you're joining us from. Happy Wednesday. Hope your week is unfolding beautifully. We got a bunch of business to attend to here today. As you can see on the title, a lot of Supreme Court stuff. We've got a 9-0 decision that came out on the Fourth Amendment, which is always something to pay attention to. And it involved a police elimination. And so we'll go through that. Not often we see 9-0 out of the Supreme Court on these things, but we got it. So we'll go through that. Then we'll also talk about this judge, Judge James C. Ho, out of the Fifth Circuit, because, man, he obliterated the Supreme Court yesterday. He dropped this one down. This is the AARP case, the case we've talked a lot about here, the Kristi Noem saga, the whole thing. Remember, the Supreme Court said on this one that the lower level judge was a bad boy and didn't act quickly enough for the Supreme Court's liking. But what has happened is the Supreme Court, of course, sent that back down to the Fifth Circuit, and the Fifth Circuit responded, and Judge Ho, in this concurring opinion, absolutely obliterated the majority in the Supreme Court, and they deserved it, every bit of it, because Judge Alito was right in his dissent, saying what they were demanding of that lower level judge was completely unreasonable. So we've got that. We've got this Fourth Circuit case in the Janice Hughes Barnes matter. Not that Robert Barnes, another Barnes, that we'll talk about before we turn our attention to another deportation battle that is brewing. And this one is going to get lit. So this one's coming out of Massachusetts. It's a Biden-appointed judge. The Biden-appointed judge just issued an order today saying, you're basically in violation of my order because it sounds like you afuera'd all of these people out of the country, right? So these are all murderers, gangbangers that Democrats love. And Homeland has already, they're gone, apparently. We conducted a flight from Texas. They're gone. The judge is saying, I said you can't afuera them, but they're afuera'd. So what are they going to do about it? We'll go through it. We got Trisha from Ohio who came out and gave us an update. And then we got a short clip here of the president getting into it with President Ramaphosa in the Oval Office today. So a bunch of great stuff to get to today, my friends. As I mentioned, I hope your week is unfolding oh so beautifully. Before we get into the business on the day, let's talk about our friends at Brick House Nutrition because, man, there is a deal that is afoot right now and you don't want to miss it. It's Memorial Day, so 25% off everything on the entire site. And that includes a bunch of good stuff, including Lean. And you may have heard about Lean. Lean is a weight loss supplement that targets the goals of the GLP-1 in injections that you see, but it doesn't have needles or the prescriptions. People are seeing real results. You can go check it out at brickhousenutrition.com, 25% off everything on the website with code MEMORIAL25. And you'll also see that Field of Greens, which we're big fans of because we like our vegetables here, also on sale. It's a fruit and vegetable drink. They promise you that your doctor is going to notice that your health is improved. If you don't see that, then you're going to get your money back. And so this is delicious stuff. I've tried it. I've used it. It is easy to drink and it's good to have your vegetables. And creatine is probably the biggest thing that I'm a fan of, and they've got that too. So no matter what you want, creatine, all sorts of good stuff, different flavors, sports drinks, electrolytes, all the good stuff. Memorial 25% off. Link is down in the description below. It's brickhousenutrition.com. Load up, get healthified, get nutrified, and eat your vegetables, courtesy of our friends at Field of Greens. And so check them out, of course. And there's a QR code you saw up there on your video if you want to click that as well. So thanks for supporting our sponsors, my friends. And now let's get into the business on the day because we've got some very good stuff to attend to. And here it is starting now. We'll start with the Fifth Circuit today because this one is a lot of fun. So the Supreme Court gets shredded by the Fifth Circuit. We've spent a lot of time on this case, the AARP WMM FGM case. And this, of course, is just a list of acronyms, pseudonyms for illegals who are not required to use their real names, because if we use their real names, then we'll know that they're like Kilmar, and there could be problems for their cases if they bring those, and we're able to discover all of that problem. But here is what is coming out of the Fifth Circuit. Now, this is in response to what the Supreme Court said previously. If you recall, earlier this week, we read through a decision, or maybe it was last week, on May 16th from the Supreme Court of the United States. And the main crux of this, really we saw in the dissent. This is a 24-pager. And if you recall, it was about deporting people out of Texas. And what happened was there was a lower level district court judge who said that the deportations essentially could happen. The ACLU came back down and their gangbang lawyers, and they sued and they said, this judge, you better respond to us within like 45 minutes because they're putting them on an airplane and they're about to deport them like right now. They said, it's an emergency and it's an emergency. And the Supreme Court bought that, right, and scolded the lower level judge. It said, the Fifth Amendment entitles illegal aliens to due process when it comes to removal. And the government is saying that they can remove these people. But under the circumstances, 24 hours is not enough. And they laced into the lower level judge. It was very inappropriate. When we read through this before, we were very unhappy about this because it was inappropriate for them to do that. And the application for the injunction was granted. And the Fifth Circuit is going to get this case back, right? We read through the full dissent here from Judge Alito, and Judge Alito was very unhappy about it. Now, what has happened is this judge is named Judge James Chuen-Yu Ho. He's Chinese, and he was actually born in Taiwan, actually. I guess his name is Chinese. Now, he's in the Fifth Circuit, and so he is a foreign-born judge. And we often rip on foreign-born judges because we wonder why we can't have domestically born judges. It's always curious to me. I think they can't find somebody from like Pennsylvania or someplace who's going to be a judge on that court. They got to, anyways, this judge came out and gave us a good opinion today. And it's absolutely accurate because it blasts the Supreme Court. And here is what Judge Ho said in response. So remember, Supreme Court gets this case. They scold the lower level district court judge, say you should have acted more quickly. You acted, it took 14 hours or whatever it was. And now they have to solve this. The Supreme Court punted this, gave it to the Fifth Circuit and said, you guys decide this. We don't really have, I guess, the capability of doing that. So why don't you guys figure it out? And here is what the very short order from the court of the Fifth Circuit has come out and said. They said last Friday, the Supreme Court vacated the judgment of our court. We already heard this case. The lower level district court dismissed the case, then they appealed it, and the Court of Appeals dismissed the case because they said, how dare you demand that the lower level judge act on your timetable, and they dismissed it. But now they say the Supreme Court remanded the case back to us and directed us to proceed expeditiously, whatever that means. So accordingly, this matter is expedited to the next available randomly designated oral argument panel, which will be coming soon, right? So not much there. In other words, the Fifth Circuit is catching the ball that the Supreme Court kicked over to them, and they'll get it scheduled. Now, the real decision comes from James C. Ho. And he's filing this in a concurring opinion. James Ho obliterates the Supreme Court in this, and they deserve every bit of it. He says petitioners who are identified as gangbangers, members of Tren de Aragua, a designated foreign terrorist organization, should not be allowed to proceed in this appeal. Now, he's going to concur in this because he's ordered to by the Supreme Court, but he's saying this is ridiculous. On April 18th, from our court, we issued an order from the Circuit Court of Appeals in Texas that we lack jurisdiction to grant the relief sought by the gangbangers. But then, on last Friday, the Supreme Court reversed our unanimous decision over a vigorous dissent by Judge Alito that we read through here that was joined by Judge Thomas. Now, as an inferior court, we're duty-bound to follow Supreme Court rulings, whether we agree with them or not. And we don't have to like it, but we have to do it. So I concur in our order today, expediting our consideration because the Supreme Court told us to. But I write to state my sincere concerns about how the district judge, the lower level judge, as well as the president and other officials have been treated in this case. And I worry that the disrespect they have been shown will not inspire continued respect for the judiciary, without which we cannot function. This is the same argument we've been making here forever. John Roberts, by being a little pansy with the rest of them and not coming out and giving us clarity on this, is undermining the credibility and the legitimacy of the court, which is to their own detriment. So it's like, well, we're going to avoid a conflict here. We're not going to wade into this political mess. And by doing that, because the justification being if we wade into that, we're going to undermine the legitimacy of the court. And then by not wading into it, they're destroying the legitimacy of the court. The judge writes, Judge Ho, It is not the role of the judiciary to check the excesses of the other branches any more than it's our role to check the excesses of any other American citizen. Judges do not roam the countryside looking for opportunities to chastise government officials for their mistake. That's not what we do. Rather, our job is to simply decide those legal disputes over which Congress has given us jurisdiction. And under the law, U.S. Code, appellate courts have jurisdiction, the law says this, to review interlocutory orders of the district court when they refuse to enter an injunction. Now, that includes orders that have the practical effect of refusing an injunction, which is what the Supreme Court basically said happened here. Now, that is demonstrably not this case. The Supreme Court made it this case. They cited that stuff to kind of make it fit, but it's not at all. The district court, writes Judge Ho, made ably and amply clear to the gangbangers that it stood ready to hear their request for emergency relief. Indeed, the court had already ruled on such requests the day before, like the judge was doing his job. The court simply advised the gangbangers that the government would get 24 hours to respond before it would issue a ruling one way or another. We got to hear from the other side before we take action. Now, the lower court also reminded the ACLU that the government had assured the court that they're not going to remove these people without first giving the court advance notice. So the government has told them, your petitioners that are a party to this case will not be afforded. Okay, so just chill out. So when the gangbangers came and they sought emergency relief at 12:34 a.m. on April 18th, midnight, right in the middle of the night, the gangbangers were fully aware that the district court intended to give the government 24 hours to file a response because the court has already said that. They said nothing about a plan to appeal this if the district court elected to wait for that response, right? At a prior hearing, they said, okay, 24 hours, fine. So then at 12:48 p.m., on April 18th, the ACLU suddenly informed the court. They said, hey, we're going to file an appeal if the district court did not act within 42 minutes. That was at 12:48 p.m. So we've got the emergency relief comes in at 12:34, so like midnight, right? Judge should be asleep. Then at 12:48, they say, hey, we haven't gotten anything from you. So it's been like 4 hours, maybe 5. Court opens 8:30, right? Then it's 12:48. They send in another motion. Hey, judge, if you don't respond to us within 42 minutes, because we already filed at midnight, and now we waited like 4 hours since the court opened. If you don't act by 1:30, then we're going to appeal you, punk. So when the court, to no one's surprise, couldn't comply with their patently unreasonable timetable, petitioners immediately filed this appeal. So they left the lower district court of Texas and came up to the Court of Appeals, which is where we are now. And so our court in the Court of Appeals, we also responded expeditiously. That night, in fact, we held that we lacked jurisdiction to hear this case. And our order explained this. It said that the gangbangers gave only 42 minutes to act, and they did not give the respondents any opportunity to respond. Now, as our distinguished colleague put it in the Court of Appeals, right, he's saying my neighbor here, who's also unanimous in this, they say 42 minutes is quite plainly an unreasonable deadline. It says we cannot find an effective denial of injunctive relief based on the failure to respond within 42 minutes. Like, we're not obviously going to do that. We're the court, we're the judge, not the gangbangers. And the gangbang lawyer also called, remember, and scolded that judge, left a voicemail on his voicemail, and said, I need you to act right now. Wake up, get out of bed. My illegals are in trouble. Now, the Court of Appeal says our decision was unanimous because it's obvious, right? 42 minutes is not remotely enough time to review and analyze all of the relevant legal authorities and prepare a reasoned ruling. And notably, the justices themselves have expressed concerns about making decisions under far more forgiving time constraints than those demanded here, right? In other words, the Supreme Court has said, like, if you act too quickly, that's going to be a big problem. And acting too quickly in those cases was much broader, like much longer time. Recall that there was emergency relief sought in this case back in 2021. He says, remember this Supreme Court, in case you guys forgot, it was called Doe's 1 versus 3 versus Mills, 2021. Members of the Supreme Court expressed concern in that case that the use of the emergency docket to force the court to grant extraordinary relief on a short fuse without the full benefit of the briefing is a big problem. And who wrote that one? Oh, yeah. Amy Coney Barrett did. Remember? So Amy Coney Barrett, if it's somebody else suing Does 1 through 3, she has a meltdown. Wow, this is ridiculous. We can't use this emergency docket to force the court to act within 42. Ridiculous. We're not going to operate here on a short fuse. We want everybody to have the full benefit of a full briefing so before it gets to the Supreme Court. Unless it's alien enemies and terrorist gangbangers, and suddenly they're like, oh, it's an emergency, and everybody pops out of bed to issue a stay. Now, the amount of time considered too short in the Doe's case was 9 days, right? Amy Coney Barrett, back in that case, in her concurring opinion, she denied the relief in that case. She said, no. 9 days? Like, you're coming to us after 9 days? That's ridiculous. That's way too fast. You need to go brief your stuff, go through the courts, and then come up to the Supreme Court, then we'll hear it. But now it's 42 minutes, and that's too long. That's like, it's malpractice for this district court judge to allow that to happen. He says compared to 42 minutes, however, 9 days is a lifetime to decide a motion. And they didn't allow that to happen when it was 9 days. They're like, it's way too fast. Slow down. So the district court in Texas reasonably assumed that the principle invoked in the Doe's case that came from the Supreme Court, where you said 9 days is way too fast, to justify denying relief to law-abiding citizens concerned about their religious liberties in the COVID-19 era would likely justify denying relief to illegal alien members of a foreign terrorist organization. Oh, that's savage, man. Amazing, right? So Amy Coney Barrett, if you're a law-abiding citizen and you're concerned that your religious liberties are being violated, and you file to say, please stop the government from abusing my First Amendment rights as an American citizen. Court, act quickly. Stop it. I'm about to be fired. We're going to lose everything. Our whole business is going under. Amy Coney Barrett and the justices said, well, we need full briefing before we can consider your rights. You're an American citizen? Get in the back of the line. No one cares. But when it's an illegal alien Tren de Aragua putative class who is allowed to proceed pseudo-anonymously in our country, you can see if you can get charged with a crime or proceed pseudo-anonymously on anything. And the answer is usually no. But they get protections because they get more due process, more rights. It's premium America if you're an illegal alien. Don't need a driver's license, don't need insurance, can traffic humans, beat your spouses if you want to, no one cares. And if you're about to be removed after the American people voted and elected a new administration to come in here and clean all this stuff up, if you're about to get deported, Amy Coney Barrett has a meltdown, pops out of bed, joins all the other ladies on the Supreme Court and says, this is egregious. We have to stop this now. The district court was absolutely right, writes Judge Ho, when it noted that issuing a competent and defensible ruling like the Supreme Court dictated to us back during the COVID era, it required some level of care, and it takes some level of care. It takes time to do that. And so Justice Alito noted in his beautiful dissent that we read, he said, we should commend this careful approach and not criticize it. But rather than doing that, Judge Ho writes, rather than commend the lower level district court in Texas for actually following what the Supreme Court said to do and give the government an opportunity to respond to this, the Supreme Court charged the district court with inaction, right? And I don't know who wrote this because they wrote it in a per curiam opinion because they're pathetic. But it sounds like Sotomayor or maybe Barrett. Says inaction, not for 42 minutes, but for 14 hours and 28 minutes is what they said. And we thought, oh my gosh, they've got George Floyd on the brain. They're doing like the 8 minutes, 24 seconds or whatever that was, the Dave Chappelle routine. Yeah. So it's 14 hours and 28 minutes. Well, it's not 9 days. Did you talk to Amy Coney Barrett, who's screaming about 9 days? This inaction, according to the court, was tantamount to refusing to rule on the injunction. And the judge already told him 24 hours. They called screaming about it and demanded this. Now, James Ho, shout out to this guy. I'm so happy he's doing this because I felt bad for the district court judge. When we watched a 7-2 Supreme Court of a bunch of pathetic people who can't come out and give us guidance on any of these cases, when they come down and they blame him in their decision, and then they kick it to the Fifth Circuit, it's like embarrassing as an attorney. You're just going, take some responsibility for your docket. Take some responsibility for your caseload. It'd be like a senior partner being like, scolding some intern who did an amazing job and then giving this big problem case to some other person and then scolding them and saying, you do this. And then that senior partner, who's supposed to be like the leader of the whole thing, claims that they're amazing, right? Everybody in the law firm would go, that guy's a lunatic. And that's exactly what we're seeing here on display by the Supreme Court. So let's explore this, because the Supreme Court botched this badly. He says, let's calculate this. If you guys want to do this 14-hour crap, how about this? To get to 14 hours and 28 minutes, says Judge Ho, rather than 42 minutes, the court was obviously starting the clock at 12:34 in the morning, rather than 12:48 p.m., which is when the petitioners told the district court for the first time that they wanted a ruling before the government could respond, right? So they submitted two motions. One was the emergency relief at midnight, in the middle of the night. And then once again, when they didn't get the ruling back, like that afternoon. 12:34, give us 42 minutes or else. Now, the clock is off. Starting the clock at 12:34 in the morning, like the pathetic Supreme Court did, not only ignores the court's express instructions respecting the government's right to respond, right? Amy Coney Barrett out of the Supreme Court said, we got to give everybody time to fully brief this matter. And the government was what told the defense, the gangbangers, we're not going to deport your plaintiffs either. So there's no urgency. It also ignores the fact that the court is starting the clock, he says, at 12:34, right? First of all, like two things here. One, the Supreme Court, told the other courts to respect the government's right to respond. That's a mandate from the Supreme Court, so he's following your rules. But they also filed it at 12:34. So forget all the legal stuff, like don't have to be a lawyer, Supreme Court scholar, went to Harvard or any of that crap. They filed it at 12:34 in the morning. Now, we seem to have forgotten that this is a district court, not a Denny's. Amy, this is the first time, says Judge Ho, I've ever heard anyone suggest that district judges have a duty to check their dockets at all hours of the night just in case some gangbangers decide to file a motion that we have to act on. If this is going to become the norm, then we should say so. District judges, say the Supreme Court, are hereby expected to be available 24 hours a day, and the Judicial Conference and the United States Administrative Office should secure from Congress the resources that are necessary to staff and to ensure 24-hour operations are happening in every district across the country. If this is not to become the norm then, which it's not, then we should admit, says James, that this is special treatment being afforded to certain favored litigants like members of Tren de Aragua, and we should stop pretending that Lady Justice is blindfolded. Absolutely right. Same thing we've been screaming about here. Why are they a putative class? Why do they get to have special protections and emergency docket hearings in the Supreme Court of the United States? Why do they get calls to the FBI who let them go when they should be arrested immediately and charged with crimes? It's because they have premium America, premium version of America. I don't know how much it costs. It's free for them. I don't know why. Well, we don't get it. If you're a COVID person, you got fired because you stood up for your rights. You don't want to do things that are in violation of your religion, and you're a free American, for crying out loud, and you sued. Supreme Court didn't give a crap about you. You're just a peasant. Stop killing grandma. Enjoy your winter of misery and death. But if you're a Tren de Aragua gangbanger, man, they bend over backwards to make life amazing for you. Now, the judge writes, I have no problem making clear when a district court has abused its discretion and thereby jeopardize the reputation of the judiciary. In fact, he's saying, look, I've got many examples of this, and I'll go find them, collecting examples. He's like, I'll find this one and this one. He's going to look them all up. But this district court judge in Texas conducted himself in a reasonable and admirable manner. All inferior court judges expect to be reversed on appeal from time to time, but I'd wager that this judge never imagined he'd be reversed on grounds of laziness. And he says, I looked into this, Judge. A brief glance at the docket suggests an extraordinarily diligent judge who somehow found the time to balance the needs of this challenging case by screaming ACLU lawyers, including a number of motions and orders throughout the week, all while presiding over a complex and sensitive criminal trial involving multiple child victims. Maybe by illegals, who knows? But this judge is handling everything. And they're like, you didn't act in 14 hours because, and this judge like had his knee on their necks or something. So any criticism, writes Judge Ho, of this district judge is unwarranted and unfortunate. And I couldn't agree more. We were reading through that. I couldn't believe the Supreme Court was being so aggressive towards him. It's like they're mad at themselves. It's like an abusive spouse or something. You guys, you broke that thing. So don't blame him or the Fifth Circuit for this. This is your business. So any criticism is unfortunate. He says, it's no wonder that Justice Alito rejected the court's decision, calling it misleading, lying, and a mischaracterization of what happened down there. As he put it, the court characterizes the district court's behavior during the period in question as an action, but he says that's unfair. This judge was working with the utmost diligence to resolve the important and complicated issues presented by this motion as quickly as possible. And moreover, a distinguished former district judge has already come forward with these pointed observations. He's saying someone else said this too. In fact, Paul G. Castle wrote about this in the Wall Street Journal after the Supreme Court came back down and acted a fool. He said, Judge Hendricks' service was exemplary. Says the majority was wrong to malign this judge and sent a disturbing message about procedural norms. We need more jurists like Judge Hendricks, and the Supreme Court should think more carefully about how its rulings could distort the work of the lower courts. Yeah, it was very inappropriate of them. It's like somebody who's like a black belt coming out and just beating the hell out of a white belt who did an amazing job, right? And was stellar and outstanding. It was pretty sick to see it. Now, the district judge is not the only public official whose treatment in this case warrants comment. Supreme Court, recall why the district court established the 24-hour filing deadline. Why is this? Because the court firmly believed that the government should have the right to express its position before any ruling is issued, and rightly so. That's how the law works. Our adversarial legal system has long been premised on the notion that judges should impartially consider the views of both sides of any dispute before issuing a ruling, obviously. And Alito commented on this, saying, the court took the entirely reasonable position that it would wait for the response before acting, as it's supposed to do. So it should go without saying that the president and his fellow executive branch officials deserve the same respect that courts regularly afford to every other litigant, including other presidents and officials. You guys, the Supreme Court, have given prior presidents the benefit of the doubt, right? Good grace, the presumption of regularity, the benefit of friendship and comity. Says one former president tried to shame members of the Supreme Court, if you remember this, during a State of the Union address by disparaging a recent ruling. Remember when Obama came out and like lambasted them, seated right there? That same President Obama also suggested it would be illegitimate for the Supreme Court to declare an act of Congress unconstitutional, right? Remember Obama said that if they nuke Obamacare, he's not going to follow it. Peter Walston and Robert Barnes wrote that one. Obama's Supreme Court comment stirred debate in the Washington Post. Now, another former president was also disbarred from practicing law before the Supreme Court. Remember when you did that with Clinton? See in the Clinton case, and see also the editorial saying when Biden ignored the Supreme Court, Biden said, right? Remember Biden said, the Supreme Court didn't stop me. I don't care. I know I'm not allowed to do that, but I did it anyways. Saying American presidents may not like Supreme Court decisions, but most of them since Andrew Jackson haven't bragged about defying its rulings. But Judge Ho wraps it up, says, yet I doubt that any court would deny any of those presidents the right to express their views in any pending case to which they are a party before issuing any ruling. And so our current president, Donald Trump, even if you don't like him, he deserves that same respect. Talking to you, Amy Coney Barrett, John Roberts, and the rest of them. This appeal should be over. Petitioners denied the district court the opportunity to rule on their emergency motion in the first instance. That alone should be enough to terminate this appeal. They're done. But the Supreme Court, in their insanity, has reversed our unanimous judgment. And so this appeal must now proceed. And so, because I've been ordered to comply, I accordingly concur. Absolutely outstanding. It feels very good to have a defense of another good judge for once. I mean, the judge in Texas did everything by the book, did everything right. The other judges, Judge Zenas, Judge Boasberg, Judge Alsup, Judge all of them, Reyes, the rest of them, are acting like lawless maniacs. And the Supreme Court isn't scolding them. Why is that? It's because the Supreme Court is not acting in accordance with the rule of law. They are enabling terrorist gangbangers to get special privileges, due process premium, American Plus. They get whatever they want. And if you sue because you're sick of your government telling you that you have to do things that are against your religion or against your freedom as a free person, they don't care. Take your sweet time. Everybody can get fired. You can go months or years without paychecks. Who cares? But if the Supreme Court sees any problems for illegals, all of a sudden they spring into action. So shout out to Judge James Ho, who was born in Taiwan, made his way to America, and is now writing banger opinions telling our Supreme Court to act like a Supreme Court, follow the Constitution, and stop creating special exceptions for gangbangers in America. Shout out to Judge James Ho. We appreciate him. We're going to keep covering this one, my friends. Of course, the Fifth Circuit is going to now hear the case and set oral arguments and have to come up with some rules to give back to the Supreme Court to see if they're satisfied with it, because they couldn't do it on their own because they're too busy lecturing lower level judges who are just doing their job. All right, so good update on that one, my friends. Now, we're going to stick with the Supreme Court and see what came down in this one, because we got a big ruling here that hits the Fourth Circuit. And here's what this one sounds like. A 9-0 ruling from the Supreme Court touching upon the Fourth Amendment. Very important amendment that keeps our government out of our lives, and we do not want them to continue to water down the Fourth Amendment and encroach upon our liberties as they normally do. So when we see a 9-0 decision coming down in favor of the citizens, we point it out. And this case came down from Judge Kagan. In fact, a bunch of people having a little bit of a eyebrow raise moment saying, even Ketanji's on this one too? All 9? Yep, it's true. Here is what the case involves. The use of deadly force and a police officer involved shooting, telling us here's what the rules are. When a police officer, we're going to get into the facts of this case, it involves Roberto Felix Jr., who's a police officer, was patrolling a highway. Someone got shot and eliminated. Here is the rule, though. They tell us a police officer's use of deadly force violates the Fourth Amendment when it is not objectively reasonable. And it's a very important concept in the law. The concept of objectivity versus subjectivity. Objectively, the question is, would an officer in that officer's same and similar position do the same thing? And if they would, is it reasonable to do that based on that officer's position? It's not the question over whether the officer subjectively believed that they in that position could do it. Like, did the officer Roberto Felix think that he was justified in that moment in time to fire his weapon? That's not the question, because his decision might not be reasonable, right? He might be off or have a misinterpretation of the scene. Objectively, if you put any reasonable officer in that position, could they do the thing? That's the question we want to answer. And was that thing reasonable? And that inquiry into reasonableness requires assessing the totality of the circumstances. So zooming in on the facts now. So the question here is whether that framework permits courts in evaluating a police shooting to apply this rule called the moment of threat rule that was used in the courts below. Now, under that rule, a court looks only to the circumstances existing at the precise time that an officer perceived the threat that caused the shoot. Today, we reject that approach as improperly narrowing the requisite Fourth Amendment analysis, right? So the Fourth Amendment was being watered down a little bit and not given the proper protections. So to assess whether an officer acted reasonably in using force, a court must consider all the relevant circumstances, including the facts and events leading up to the climactic moment. So kind of a question here. Moment of threat. It's like, how big of a window are we talking about in order to assess the facts to determine whether that cop was acting objectively reasonable? Is it just like milliseconds? So the cop, and then shoots, or is it everything that leads up to that moment that can be considered? Here's the background. On the afternoon of April 28, 2016, a long time ago, Roberto Felix Jr. is a law enforcement officer patrolling the highway outside Houston. Got a radio call. Alert about an automobile on the road with outstanding toll violations. Random vehicle. Felix, the cop, spotted the car. It's a Toyota Corolla. Turned on his emergency lights to initiate the traffic stop. The driver was this person called Ashton Barnes, pulled over on the highway shoulder. Cop parks his own car just behind, and then Felix walked to the Corolla's driver's side door. Asks Barnes for his license and proof of insurance. Barnes said, well, I don't have my license with me, and that the car was a rental in his girlfriend's name. Not even my car, it's a rental. As he spoke, Barnes rummaged through some papers inside the car, causing Felix to tell him to stop digging around, right? Cop says, hey, stop digging around in there. Cop says, hey, I also smell marijuana in there. Is there anything in the car I should know about? Driver Barnes said, hang on, I might have some ID in the trunk, so let me get out. So Felix told him, open the trunk from his seat. He says, all right. Barnes did so and turned off the ignition in the car. And all that happened in a dash cam recording in less than 2 minutes, right? So cop pulls him over, goes to the passenger side. Hey, license, registration, don't have any of it. It's a rental car. Might have something in my backpack. It's in the trunk. Open the trunk. Smells like marijuana in there. Anything going on? Then things began moving faster. With his right hand resting on his shoulder, Felix told Barnes to get out of the car. Barnes opened the door, but did not exit. Opened the door, instead turns the ignition back on. Felix then unholstered the gun, the cop, and as the car began to move forward, jumped onto the door sill. So the door's open, and sounds like he might be inside the vehicle. So the door is here, right? And he kind of jumps in, maybe holds onto the door, and he puts his foot on the floor of the entryway. Unholstered the gun, and as the car began to move forward, jumped onto the door. He twice shouted, "Don't effing move!" And with no visibility into the car, because his head was on the roof, right? So he's like got his foot on the floor, probably holding onto the door, has his gun out, head is over the car, and above the roof, he fired 2 quick shots inside, right? So now he's standing up there, probably one hand on the side door, pops off, can't see anything, fires 2 shots. Barnes was hit, but then managed to stop the car. Felix then radioed for backup. By the time it arrived, Barnes dead. All told, 5 seconds elapsed between when the car started moving and when it stopped. And within that period, 2 seconds passed between the moment Felix stepped on the door sill and the moment he fired his first shot. So door opens, ignition comes on. Sounds like the car starts rolling a bit. Stop the car, comes to an end. So then Barnes' mother sues. Janice Barnes sued Felix, the cop, on her son's behalf, brought under Section 1983, saying that his rights had been violated because of the Fourth Amendment rights and the use of excessive force against him. Now, the district court granted summary judgment to the cop, right? She sues. You can't just shoot him like that. You didn't even see him. The car was just moving forward. It's not a deadly use of force, whatever. They granted summary judgment to Felix. She sues for a civil rights claim, saying he's dead, Fourth Amendment. The court explained, sorry, Mom, you lose. You would have needed to show that Felix's use of force was objectively unreasonable, right? So he couldn't, shooting him was objectively unreasonable. Like nobody in that position would have shot him. In the usual excessive force case, the court noted at the lower court that the inquiry into reasonableness would involve considering a variety of circumstances. So like what is reasonable? Because, I mean, the argument is the dude he's got a deadly weapon. He's got a car. He's driving the car forward. He could run you over, kill somebody. Maybe he's fleeing felon. There's lots of reasons. But when the officer has used deadly force, the court continued. It said the Fifth Circuit was a much narrower approach. Okay, so like excessive force, if you're going to beat somebody, break some bones, crack their head, bunch of cops beating the hell out of somebody, then you can consider a bunch of stuff, a variety of circumstances to make your analysis. But if it's deadly force, then we don't do all of that. We don't accept all of those details. It's much narrower, they said. If it is someone is dead, a court could only ask about the situation that existed at the exact moment of the threat that sparked the shooting. So you don't talk about the odor of marijuana. You don't talk about anything else. It's just like instant, like what was in that instant? The district court said, okay, so if we can only talk about that instant, it identified the moment as the 2 seconds before Felix fired his first shot. So rather than like 2 minutes, it's down to 2 seconds. Now, when he was standing on the door sill of the moving vehicle. So we're not asking like, should he have been standing on the door sill? Was anything else appropriate for him to be there or anything else? Just at that moment. At that moment, the court found an officer could reasonably think himself at risk of serious harm, right? He's standing on the door sill. The vehicle is moving. He could fall under the door sill, fall under the vehicle, get run over by the back tire, could be dead. And under the Fifth Circuit's rule, that fact alone concluded the analysis. They said, man, he could fall off there, he could die. The court explained that it could not consider what had transpired up until those last 2 seconds, including his decision to jump on the door sill. He could have just not gone on there. Although a more robust examination might have aided in assessing the reasonableness of the shooting, the court was duty-bound by the circuit to limit the focus onto the exact minute, right, which is that moment that Felix was hanging on to the moving car. So you can't ask, should he have been on the car? Should he have grabbed the sill? Maybe not have done that. The Court of Appeals affirmed it. The district court said, yep, he's fine, fair shooting, because he could have died while he was standing there. We don't have to ask how he got there. Explaining that it too was bound by the circuit's moment of threat doctrine. And under that rule, the panel agreed. They said, yeah, the inquiry is only confined to whether the officer was in danger at the moment of the threat that resulted in the use of the deadly force. So, could he have died by standing on that sill? He had to shoot him to stop that from happening. Any objective officer could have made that same determination, and so it was valid. Any prior events that led up to the shooting, including the actions of the officer, they said were simply not relevant. So what if he jumped on there when he didn't need to? Could have just chased him, tracked him down. Maybe he wouldn't have fled. Maybe he's turning the keys back on to turn the radio on or charge his phone or something. Who knows? And here, as the district court found, the precise moment of the threat was 2 seconds when Felix was clinging to a moving car. Now, because Felix could then have reasonably believed his life was in danger, they said, his decision to shoot did not violate his constitutional rights. Another judge in a concurring opinion at the lower court, Judge Higginbotham, expressed concern with this in a concurring opinion. He thought the rule was inconsistent with this court's directive to assess the reasonableness of the use of force, including deadly force, by looking at the totality. Under the totality approach, not the moment of threat, so it's like everything or nothing. Big Venn diagram or very small one for the moment. If we use the totality approach, the judge wrote, a court could consider not just the precise millisecond when the officer deploys force, but everything that transpired up until that time. And with that wider focus, they would have found that Barnes was unreasonably shot. And so the Supreme Court granted this to address the claim in resolving the Fourth Amendment excessive force claims. They say to answer this question, and we hold that they may not use the moment of threat rule just described, because the rule constricts the proper inquiry into the totality of the circumstances, right? So cops just can't put themselves into a position of danger and then shoot somebody and say, well, I was fearful in that moment. Okay, but you kind of caused that moment, didn't you? Maybe. Let's see what they say. A claim that a law enforcement officer used excessive force is analyzed under the Fourth Amendment. The touchstone of the Fourth Amendment is reasonableness as measured objectively. It's not whether you individually think what you did was reasonable. It's whether any person in your position would also think it was reasonable. So the question in a case like this one, as the Supreme Court is often held, is whether the force deployed was justified from the perspective of a reasonable officer on the scene taking due account of both individual interest and the government interest. Now, that inquiry is about the totality of the circumstances, and this is not an easy to apply legal test. It's not like an on or off switch. It's a lot. Criminal defense attorneys make their money in this area, right? The Fourth Amendment requires, as we once put it, that a court slosh its way through the fact-bound morass of a specific case. Or said more prosaically, deciding whether a use of force was objectively reasonable demands careful attention to the facts and circumstances around the incident that were known to the officer. For example, the severity of the crime prompting the stop can carry weight. And these were toll violations, right? So too can actions the officer took during the stop, such as giving warnings or otherwise trying to control the encounter. And the stopped person's conduct is always relevant because it indicates the nature and the level of the threat, either to the officers or to others. And so, most notable here, Supreme Court writes 9-0, the totality of the circumstances inquiry into a use of force has no time limit. It's not just those milliseconds. Of course, the situation at the precise time of the shooting will often be what matters most, but it is, after all, the officer's choice in that moment that it's under review. It's important, but earlier facts and circumstances may also bear on how a reasonable officer would have understood and responded to later ones. Or, as the federal government puts to the point, those later in the moment facts cannot be hermetically sealed off from the context in which they arose. Taking account of that context may benefit either party in an excessive force case. It might benefit the government, saying, look what this dude was doing, that's why we had to shoot him, or it might benefit the defendant. So it's not like a one-sided rule. Prior events may show, for example, why a reasonable officer would have perceived otherwise ambiguous conduct of a suspect as threatening. It's like in that millisecond, he didn't seem like he was going to shoot you, but he was saying it for the last 5 minutes. And so, all right, we need to consider those 5 minutes. Or instead, they may show why an officer would have perceived the same conduct as innocuous because of what happened 5 minutes ago. The history of the interaction, as well as past circumstances, may inform the reasonableness. And our prior case called Plumhoff illustrates this. In that case, there was an excessive force claim that concerned the fatal shooting of a driver at the end of a dangerous car chase, lasted more than 5 minutes, right? The driver had sped away from a traffic stop, tried to outrun 6 police cruisers, 100 miles per hour. Eventually, the fleeing car ran into cruisers, came to a near standstill. Now, that driver still tried to escape, pumping the gas in a way that sent his wheels spinning and then putting the car into a reverse. At that point, one of the officers fired several shots into the car in a suit brought against the officer. The driver's daughter said, "Those shots shouldn't have been fired. It was already over." But the court said no. This court rejected that claim based on everything that happened. The driver's outrageously reckless behavior, 5 minutes of lunacy. His last seconds, he was trying to, again, take flight again. So they shot him. Given all those events, the court explained, a reasonable officer would have shot him too. Said, nope, he was intent on resuming the getaway. He posed a deadly threat to others. And so the shooting was justified at the moment because of everything that transpired before that. Now, the moment of threat rule that was applied in the courts below prevent that sort of attention to context, and it conflicts with the rules. Recall that the district court and the Fifth Circuit limited their view in this case to the 2 seconds before the shooting, after the cop jumped onto the doorsill. Those courts believe that under the Fifth Circuit precedent, they could not take into account anything before that. So they could not consider the reasons for the stop, or the earlier conduct of the person, or the interactions between the suspect and the officer. And because of that limit, they could not address whether the final 2 seconds of the encounter would look different if it was set within a longer time frame. Now, it is as though the court in Plumhoff could consider only the instant when the car chase was at a near standstill and not when it zigzagged and hitting all these other things. They say, to be sure, historical facts often will not matter as much in the reasonableness analysis, and some of those facts that came earlier may not be relevant at all. But no rule that precludes consideration of prior events in assessing a police shooting is reconcilable with the fact-dependent and context-sensitive approach that we've described before. A court deciding a use of force case cannot review the totality of the circumstances if they're blinded chronologically. And so the point is so evident that not even Felix quarrels with it. His defense of the decision below instead relies on taking a different view of their meaning in the question. First, the agreement with what we have said is from Felix. He says, yes, he acknowledges prior events are not off limits in this inquiry because they can inform the perspective, right? Like, in other words, even the defendant is making this point. But now is the divergence. According to Felix, the courts below acted consistently with that all times considered principle, right? In other words, like, they did actually analyze everything, and I was reasonable in all of the things. So their decision was actually broader than just the moment of threat segment. Saying the Fifth Circuit's moment of threat doctrine, he argues, allows courts to assess those pre-shooting facts and circumstances, and in other words, they did that. Now, all that doctrine bars is a single kind of inquiry into whether their earlier error created the need for deadly force. So it's a little bit more nuanced. He says an officer doesn't lose his right to defend himself because of a mistake he previously made. But whatever might be said of their law, generally in the Fifth Circuit, the Supreme Court says, the decisions below applied a rule about timing. Even if it was broader, their rule in writing was about timing. As shown above, both lower courts took pains to explain that in evaluating a reasonableness of a shooting, they can only look at 2 seconds or so. And because that was the reasoning, we got to address it here. It could make no difference to our decision here if the other cases eschewed a strict time limit, as Felix claims. And anyway, we're not sure that the cop directly and correctly describes the overall state of the law anyways. In the Fifth Circuit, the court noted that a recital of several historical facts might be relevant and that the totality of the circumstances inquiry is also happening. Now, as we have explained, the court cannot thus narrow this into a single moment. Now, we also don't address here a different question about other use of force cases, about whether an officer's own creation of a dangerous situation factors into this. Like maybe you shouldn't have jumped on that window sill, that door sill. As in another of our recent Fourth Amendment cases, that issue is not before us properly. The courts below never confronted the issue precisely because their inquiry was time-bound. In looking at the only 2 seconds, they excluded from view any actions of the officer that allegedly created the danger that necessitated the force. So, to use the obvious example, the courts below did not address the relevance of any of Felix stepping onto the door sill. And because they never considered that issue, it was not the basis of this claim here. The question to us was one of timing alone, whether to look only at the encounter's final 2 seconds or to the whole thing in context. And with that matter resolved, we return everything else to the courts below. It's for them to now consider whether the reasonableness of the shooting was reasonable using the lengthier time frame we've prescribed. So they're not giving us a decision on the judge, on the cop, but they're just saying your analysis was bad. You got to look at the whole thing. And that makes sense, right? You want cops to be accountable for the entire length of time, and you want the defendant to be held accountable for the entire length of time and have context about it. I think the rule as it was written before was a benefit to the police, right? If you could just justify it in those 2 minutes, then you're good enough. And that makes your task much easier to accomplish. So accordingly, we vacate the judgment of the Court of Appeals and remand the case for further proceedings consistent with this opinion, so ordered 9-0 by the Supreme Court. And so it'll go back down to the Fifth Circuit and we'll see what they do with this. Actually, should go all the way back down to the district court and they can revisit their summary judgment motion to see if the claim can continue. But I would imagine that the defense will have a bunch of other additional things they can introduce into this to say why they think it's reasonable. Mom will have the opposite arguments made, and we'll see where it goes. But the Supreme Court, I think, giving us a good ruling on this one, that the Fourth Amendment is strong, cannot be watered down. We must consider context. We don't want invasions of our rights that are endorsed by the courts as the amendment slowly gets evaporated in front of our very eyes. So a good decision, 9-0. We'll see what comes next on this one. All right, now we've got one final update on the day before we hear from you. And now we're in the District of Massachusetts, and this one is involving more deportations that are going to be coming to a head here very soon. And so let's jump into this one. A judge is furious at President Trump for deporting people that the judge said shouldn't be deported. We have a couple of filings that we'll read through, but one in particular came from this judge, Brian E. Murphy, and he is a Biden appointee who is now seated in the District of Massachusetts. And what is happening here is you'll notice that Homeland Security told us today, we conducted a deportation flight from Texas to remove some of the most barbaric, violent individuals illegally in the United States. And they're gone. And they pointed out who these people are, but the judge is saying they should not have been removed. And so the case, of course, is this one, DVD versus Homeland Security, one of the many illegal alien cases that they are fighting so hard for. Brian Murphy is the judge that has this case in his courtroom. And what we saw from the Trump DOJ came out in the form of this filing. You see that they submitted an opposition to the prohibitions on the deportations. Okay, so the DHS wants to continue to send these people out of here. And they're opposing the request to prevent them from doing that. They submitted this into the court, not a long filing. They say, this court should deny the motion for a TRO. Why? Their request for relief to facilitate the return to the United States is extraordinary in a case arising in a district court, saying for many reasons, you lack jurisdiction to order us to return these people that are already gone. And the procedures that we received, that this person, OCG, received during his removal proceedings comport with any due process requirements since they've already been removed. So we're not bringing them back. This court should deny the motion to bring them back. Saying here's why. We know the factors for a preliminary injunction. And, they actually published this dude's alien number. The government says, oops, sorry about that. We published his name on the docket. It's an inadvertent error. We apologize to the court. Sorry about that. Saying here, they are not going to win. Here's why. They say Section 1252 bars claims arising from 3 discrete actions, which are removal orders. Congress spoke clearly and emphatically, saying that no court has jurisdiction over the removal proceedings. Now, while this court has already held that you have jurisdiction over legal arguments raised by the gangbangers, it is quite another thing to order us to return an alien who we've already removed to a third country at the time this lawsuit was filed. Ordering the return of this dude who's gone is directly contrary to this purpose. While aliens within the United States have not yet reached the culmination of the removal process, this guy's removal was culminated in his removal over a month before this suit was even filed. Now, ordering his return would deconstruct, fragment, and ultimately prolong his removal from the United States. This court should therefore deny the motion. Bunch of redactions here. Saying, unlike other aliens for whom this court found the procedures available could be legally sufficient, insufficient, or logistically impossible, that's not what happened here. This guy had several opportunities to have his FEAR claim to Mexico reviewed. And it was. And his claim is barred. Here's why. Redacted, 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 redacted. And unlike other aliens in this class, this guy had an opportunity to file a motion to reopen his case, but it ended in February. There was no indication that he reopened it. However, because the opportunity nonetheless existed, his case again differs from other class members and is barred by this law, which requires they seek relief from removal orders through the immigration system. He can't sue in your court, judge. And even still, OCG could file a sua sponte motion to reopen this in the immigration courts as well. But he didn't do that either. And so he cannot claim that he lacks judicial review. He got plenty of it. He got plenty of due process. Now, additionally, while the plaintiffs point to many Court of Appeals decisions ordering the return of aliens to the United States, these cases are distinguishable because the alien was ordered to return in the context of a petition for review. The alien had not already been ordered removed, or it was invalid and stayed. And so we're not going to be bringing this guy back. Here's why. Independently, judge, if you order the return of this person, OCG, it would violate FARA. FARA says no court shall have jurisdiction to review these claims, and this court has seemingly recognized that these regulations do not demand the relief that they're seeking here. And no court, especially not the district court, has jurisdiction to review our decisions in this case. And finally, as this court seems to recognize, there is no statute or regulation requiring the return of this person. We maintain that he got all the due process which he is due. Due process does not require another round of proceedings after he got a final order of removal. He was never admitted to the United States. And so when a move-in fails to establish that they're going to win, we don't need to analyze this anymore. As explained, OCG is not likely to succeed. He's not entitled to preliminary relief, and so therefore you should deny the order. Now, that came in from Trump's DOJ saying, we're not bringing this dude back. He's already gone. The judge responded to this and is not happy. Says plaintiffs have moved for a TRO to prevent non-citizen removals to third countries, including but not limited to Libya and Saudi Arabia, without prior written notice and a meaningful opportunity to raise their claims. This judge agrees with them that this motion should not be required as the relief was already granted. And so I'm not going to consider this as a second motion. I'm just going to consider this as clarification. Now, the judge wrote this: the April 18th preliminary injunction requires all third-party removals to be preceded by written notice to both non-citizen and counsel, so they have a meaningful opportunity to raise a claim. The April 30th amendment clarifies that Homeland may not evade this injunction by ceding control over non-citizens to like the DOD, right? If there's any doubt, the court sees none, the allegedly imminent removals, as reported by news agencies, would clearly violate this court's order signed by this judge on May 7th, so some time ago. But when we look at this docket right now, those people are gone. So you can see that they have been deported, and the latest on this docket is up here from the judge, and he says, down here from the judge, writing, the clerk's notes for the motion hearing held in person, saying, at the request of counsel, the court conducts a sealed hearing with counsel. Argument was heard in the court. The court discusses the motion on the preliminary injunction currently in place. Defendants are going to file further declarations about the removal of these people, and the response is going to be extended for weeks. Now, on May 20th, at today's emergency hearing, the court ordered Trump to maintain custody and control of class members currently being removed to the South Sudan or any other third country to ensure the practical feasibility of their return. While the court leaves the practicalities of compliance to Trump and their discretion, Trump has ensured, and the court expects, that class members will be treated humanely. The court further orders Trump to be prepared to identify by name the affected class members and to address the time and manner that they got as to their removal, what opportunity each individual had to raise a fear-based claim, and in the event that they determine that this one person is not a member, be prepared to talk about the details of the removal, when and why he was removed, the names of the individuals involved in the removal, blah, blah, blah. So, and they want to know where he is currently. So they've been removed. They had a hearing on it today, and it looks like it's still going to be pending. And the judge, I was expecting more from the judge. I thought he was going to be more angry today, but he's giving them a bunch of additional time to respond to this. Now, Homeland Security came out, said, we conducted a deportation flight. All of these people are gone, and they've been charged with accused of some serious heinous stuff. Homicide, armed robbery, false impersonation, and much more, all now gone. Tricia from Ohio explained what happened today, and here is what she said.
Thanks to the courageous work of the State Department and ICE and the President's national security team, we found a nation that was willing to accept custody of these vicious illegal aliens. We are removing these convicted criminals from American soil so they can never hurt another American victim, American man, child, or woman. They can never attack witnesses, families, victims, or anyone else. Now, a local judge in Massachusetts is trying to force the United States to bring back these uniquely barbaric monsters who present a clear and present threat to the safety of the American people and American victims. While we are fully compliant with the law and court orders, it is absolutely absurd for a district judge to try to dictate the foreign policy and national security of the United States of America. These are the monsters that the district judge is trying to protect. The contrast is brutally stark. President Trump and Secretary Noem are working every single day to get these vicious criminals off of American streets. And while activist judges are on the other side fighting to get them back onto United States soil.
All right, so not much happened in court today. I thought the judge was going to be screaming at him for removing these people, but basically not. He says, file your declarations. Arguments heard on the joinder of the DOD, right? These people got sent to the DOD. Bring them in, and the court is going to schedule an evidentiary hearing if necessary to dig into why these people were removed and how they can get them back. But Tricia from Ohio explained that these are bad people who are gone. And the question, of course, is why are the judges wanting them back? Now, Trump was also in the Oval Office today with the president of South Africa called Ramaphosa. And we also have been talking about the immigration situation with the Afrikaners coming to America. And Trump got into it with this guy today, asking him about the genocide of white people happening in his country.
We have hundreds of people, thousands of people trying to come into our country because they feel they're going to be killed and their land is going to be confiscated. And you do have laws that were passed that gives you the right to confiscate land for no payment. You can take away land for no payment.
I want to clarify that because we have a constitution. Our constitution guarantees and protects the sanctity of tenure of land ownership. And that constitution protects all South Africans with regard to land ownership. However, we do say, because we've got to deal with the past, the government, and as your government also has the right to expropriate land for public use.
And you're doing that.
And we've never really gotten underway with that. And we are going to be doing so.
You're taking people's land away
we have not.
From them.
We have,
and those people in many cases are being executed.
Yeah.
They're being executed. And they happen to be white, and most of them happen to be farmers.
Mm-hmm.
And that's a tough situation. I don't know how you explain that. How do you explain that? They're taking people's land away, and in many cases those people are being executed, and in many cases it's not the government that's doing it, it's people that kill them and then take their land, and nothing happens to them. But we have thousands of people that want to come into our country. They're also going to Australia in a smaller number. But we have thousands of people that want to come into our country, and they're white farmers, and they feel that they're going to die in South Africa, and it's a bad thing. Yeah.
All right, and Trump said, hit the lights, and played the highlight reel of the white genocide happening in South Africa. And of course, the media has gone bananas over that. So certain groups of people are worthy of defending, others are worthy of not. And Trump called it out today, and it was a beautiful sight to see. And so, my friends, what a great day it has been. If you're just joining us, we covered 3 good segments today. We talked about the Supreme Court and how Judge James Ho out of the Fifth Circuit in Texas obliterated the Supreme Court and rightfully called them out for being ridiculous. They castigated a lower level district court judge completely inappropriately, and the judge broke down exactly how wrong they were. Said, how ridiculous is this that you want a judge to answer his docket at 12:30 in the morning and then lecture him for not responding in 14 hours when your prior precedent said 9 days was too fast? Give me a break. So Amy Coney Barrett got called out there to her face by a circuit court judge, and it was a beautiful sight to see. Then we talked about the Fourth Amendment and the 9-0 decision, which is saying, yeah, cops, you got to, analyze the totality of the circumstances. You don't just get that moment of justification to provide when you're challenged in an OIS. And we saw unanimity there out of the Supreme Court. Then we turned our attention to this judge, Brian Murphy, who is a Biden appointee who is ordering essentially, or now it sounds like entering into discovery over the deportation of some very violent people, wants to know how they got out of here, where they are, and whether he can get them back. And so we'll continue to cover that. But now, my friends, it is time to hear from you. And let's see what you say about this on this lovely Wednesday. Hopefully your week is amazing and you're accomplishing everything you set your mind to. Thank you, Donna. Thank you, John, for clipping away for us. And welcome to new members. We had a great members only stream this morning It's Wednesday. Happy Wednesday. And thing. Also, happy Wednesday, my friends. Hey, A-Train in the house. A-Train just became a supporter. Good to see you, A-Train. Grab the Membo stream from this morning. Tim Bledsoe, welcome to you too, my friend. See you tomorrow on the members only stream. Street K9 is here. 7 months as a Membo. Thank you, Street K9, for being here for 7 months. 2 months to go. We got a full baby in the house. Will Crump says, what if the Fifth Circuit fires back at SCOTUS again on the rehearing and says, my ruling is still the same. I got it right the first time. Well, like SCOTUS basically ordered them to figure out what the right due process is. Like, what is the right notice? What is the right opportunity to be heard? It was so pathetic. The Supreme Court could just tell us if they have an idea. But instead, they just wanted to lecture the new guy, the district court judge, and then make someone else do their work. That's how weak they are. Thank you, Will Crump. Hey, Savage Studios says, Judge Ho is the judicial equivalent to POTUS's White House Deputy Chief of Staff, Stephen Miller. Stephen Miller's the man. Yeah, and Judge Ho, man, and I got to eat my words on this. You know, we kind of rip on a lot of foreign-born judges all the time, but he's a foreign-born judge, and he crushed that one, I'll tell you that. Bill Dozer, this is not a Denny's. Judge Ho also just passed 300 views over there on Rumble. Woo, Bill Dozer, baby. Get some. Man, are you guys following Bill Dozer over on Rumble? Bam, one day I'll reach Rob level. Probably much faster than me. Thanks for all your hard work, Rob. Thank you, Bill Dozer. Keep streaming, baby. Keep publishing. Anybody in the content game, publish. Don't let up. Good work, Bill. Uncle Bozy. I had high hopes for Justice Barrett, but at this point, I've had it. I'm going to get slammed for this, but I'm just done with women SCOTUS justices. If past practice is an indicator of future performance, yeah. From Sandra Day O'Connor to Amy Coney Barrett, they have betrayed the Constitution and us time and again. They were supposed to be constitutionalists, but it appears they hid their biases during their confirmation hearings. At this point, I don't think any woman is fit to serve as a federal judge at any level, much less SCOTUS. From Uncle Bosie. Interesting comment. Mizzy M. It's a better news week, it seems. Glad you can keep up with it all. It is wearing to listen to and make sense of, but glad you were up for the job. Thank you, Mizzy M. Thank you, Mizzy M. I appreciate that. Yeah, sometimes it can be a lot. What's up, Matt? But we're making America great again, baby. We're saving our country. We have to expose the bad judiciary. And so it's a real honor and a privilege, Mizzy M. Thanks for being here and joining us. Melanie Snare says this case is all about the timing to goad the U.S. to say it wasn't enough time to provide the ACLU claims that Tren aren't given enough time. Yeah, and I think you're talking about the 14 hours case. And I guess the question is, why is the Supreme Court suddenly having this urgency for this special class of people, which I think is what Judge Ho was pointing out. It's like they're setting up an exception for the gangbangers, and they're saying it's under due process protections, when that's exactly what the judge was doing, giving due process to the government. Like, why does the government not get due process? Why do judges have to act instantly for Tren de Aragua gangbangers and nobody else gets that privilege? Why is that? Yeah, because they love them. Uncle Bozy, maybe I missed it, but name one female judge that has ruled in favor of the Trump administration. There's one. There is one. We covered it. But I can't remember her name. I'm pretty sure we covered it. It was a good one. I thought the same thing, like, wow, it's female. That's great. I should have called. We'll call it out next time. Next time we see one, we'll call it out. But don't hold your breath. Sheila Poo, SCOTUS has obviously become supremely political and partisan. The decision, Judge Cannon, there you go. Judge Cannon is great. That's a great comment. Judge Cannon, boom. Thank you guys for the assist on that. Yeah. So Judge Cannon, there was another one more recently, though, on these injunctions. Judge Cannon in Florida has been awesome. There was one that we covered recently that was a female injunction. It was an injunction case. I think it might have been out of Texas. But Judge Cannon, yeah, Judge Cannon's a good one too. Definitely not on the Supreme Court though. Dark Rogue, what's up? I don't fail to see actually, Kagan has come down and rejected some injunctions. I think we read one yesterday where they rejected an injunction. But I get your point, Uncle Bozy, and it's definitely provocative. Dark Rogue, what's up? And Sheila Poo says, SCOTUS, obviously become supremely political and partisan. The decision on the Texas case was clearly incorrect. And it was rude and condescending and just beneath the dignity of the Supreme Court. I can't believe 7 people wrote that and signed off on it. John says there was one on a 3-panel appeal that was good. I'm kind of remembering it. We'll call them out now. We'll just call out the judges. Dark Rogue. I don't fail to see the irony that the gangbanger attorneys file suit in the Fifth Circuit about due process for their gangbangers, yet they can't abide by the court's own due process. Yeah, no, they keep screeching about due process for their clients, but there's no due process for the government or for the American people who voted to have an administration come in and correct this problem. Yeah. Will Crump, SCOTUS said zilch about the NAACP's ex parte attempt. So egregious, the judge documented it in detail, and yet SCOTUS blew it off totally. Yeah, honestly, I think that SCOTUS was looking for a justification to reach the outcome that they wanted, and they just found a useful scapegoat, which was totally offensive because that judge did nothing wrong. Hey, Elena, a.k.a. Neely in the house, bringing in 5 new members. Thank you, Elena, for doing this. Thad the Man is here. Just Jama, welcome. Shadow Seeker, David Mokhtaloff is in the house, and Mark Diamond, gifted members, courtesy of Elena, a.k.a. Neely. Thank you, Neely. Doan is here. Why would SCOTUS get involved when Felix simply violated existing rules of engagement? Isn't there existing due process for that type of engagement? Yeah, I think they probably just noticed what the Fifth Circuit was doing and didn't want that to catch, right? They didn't want that moment of incident, moment of threat standard to percolate. So they just kind of nipped that in the bud right away, I think. And again, they weren't even making a decision on what Felix did specifically. They said, go, send that back down, just broaden your analysis and then decide. Mock Schnell, what's up? Hey, Mock Schnell, bringing in 20 membo friends. Thank you, Mock Schnell, for bringing these folks in. Viva Cristo Ray is here. Alaskan Sauce, what's up, Phoenix? JK, Rocket Dan, Jim Tells You. We got Mr. J, Ron Jones, Scott 19D, just me. We got Valerie Guerre. What's up, Dwayne Anderson? Jonathan Cardass. We got Eris Akers, Walter Swank. What's up, Swank? Tony, Don't Care Anymore. Welcome. D. Maurier, Kim Jong-un, North Korea is best Korea. Welcome. Mountain Cat, what's up? David Monton and Digital Anon, gifted membos, courtesy of our friend Mock Schnell. More speed in the house. Thank you, Mock Schnell. Says, per our discussions this morning, I love all groups' conversations. Sometimes I get a troll in my gifting, but that's a good thing, as they see how civilized people interact and learn from all of us. Thank you, Mock Schnell. Yeah, it's good. Sometimes the trolls will come and join us. They'll get gifted a membo and come join us on the membos streams and hopefully no longer be trolls because they'll realize how nice and pleasant everyone is. Hey, Potato, Defective Potato says, does the Fourth Circuit SCOTUS 9-0 ruling justify cops putting themselves in danger just to claim self-defense when shooting fleeing suspects? No, I think it actually reverses that. Yeah, I think it reverses that. I think that the prior rule, like if you look at the totality, then you could say that cop shouldn't have done that thing and caused the scenario that required the shooting to occur. If you just limit it to that. If you close the window, then you can basically make any shoot look justified. But if the cop put himself in that position there, the narrow window would foreclose that analysis. So I think it actually reverses that. Tony, hey, Rob. For some reason, I can't be seen on the chat on YouTube. I talked to YouTube. They're looking into it. I was wondering if something you can look for. Yeah, I can, Tony. Hey, I don't know why that happens, but yeah, I can definitely take a look, and I can even make you just an approved person, I think. So I can do that. Sheila Poo says, this decision was difficult. I tend to fall in favor of the ruling because the person was killed was originally stopped for toll violations. The cop was overly aggressive. I think that's probably right. Like the cop, they noted that. I'm sure the Supreme Court watched some of the footage and they noted the cop probably had his gun on. He's probably hyper aggressive. It was a toll violation. Like, come on, he's a rental car. Toll violation for a rental car. Like, was it really a rental car? So I'm sure that it's not as, there's probably more to it. And the Supreme Court wanted the right outcome. Robin Collins, what's up, Robin? Thank you for becoming a membo. Great to have you aboard. Sheila Poo says, like, share, subscribe if you can. Thank you, Sheila, for the reminder. To everybody out there, if your thumbs work, we'd appreciate a like on that one. Will Crump says, if any citizen lies in court, it is perjury. What crime is committed when SCOTUS knowingly lies and rules improperly based on that lie? They're the Supreme Court. So, are they under oath per se? I don't know. Could you charge them with anything? Unlikely. You can impeach them, and judges have been impeached before. There was a judge, a Supreme Court judge, one Supreme Court judge I think was impeached ever, Samuel Chase, and he wasn't removed. He was just impeached. The Supreme Court during its early years was a mess. They were prosecuting Republicans left and right. It was wild. Hey, former LEO. With the LEO standing in the area between the open door and the doors opening in the car's body, my belief is the LEO made the only choice possible. Standing, speaking with the driver who suddenly started the car, put it in gear, accelerated left the LEO with two options: let go, possibly be run over, or jump into the sill of the door opening. Both of these were possibly a deadly decision. To say the LEO wasn't facing a possibly deadly outcome for the LEO, this should not alter the rulings. Well, he might still be vindicated. You might be absolutely right about that, right? It's going to go back down. They'll do the analysis, and we'll see what they say. But the Supreme Court just said you got to consider all of the things, not just that jumping on the sill moment. So you might be absolutely right about that. Sheila Poo says, agree. These crazy judges need to put these illegals up in their home. If they want them back, you can take them in. Yeah, and have them in your neighborhoods and just deal with them as you'd like. Doan says, Sky News says Trump ambushed Ramaphosa. It's beautiful. Yeah, and I saw a lot of headlines with the word baseless in there as well. Harold Greer, what's up? Bringing in 5 new members. Thank you, Harold, for bringing in Leah. James Whedon, what's up? One more rock is here. LB and Ben Mahler, all gifted members, courtesy of Harold. Thank you, Harold. Sandy says, I wish Judge Ho would have said 24-hour restaurant Denny's instead of just Denny's, because this needs to go into the history books for children to understand what took place during this time with the president. Denny's won't be around, so it won't make sense in the future. First of all, Sandy, I hope you will retract that statement, okay? Denny's is not going anywhere. They're going to be around for the next 5,000 years, no matter what. Sandy, from now on, SCOTUS is required to respond to cases in 14 hours and 28 minutes, according to their new precedent. That's exactly right. That's a great comment, too. Oh, where's your ruling, you lazy bum, Amy Coney Barrett? What are you, just sitting on your bum in there? How come you're not responding within 14 hours? They should catch hell for their months delay in deciding. Especially, it's like only illegals get that real quick action. The rest of us, 9 days, you're going to lose your job. You're going to get kicked out of the military. Shut up, peasant citizen. SCOTUS scolded the Texas district judge to teach him and others a lesson. Rule like Boasberg against Trump and you get praise. Rule like Hendricks and you get humiliated. From Sandy. Yeah, Denny's is just like IHOP. It's not gross. It's delicious. A grand slam from Denny's. Are you kidding me? Michael Ryan, what could Trump do about getting overruled by rogue judges? Just sub to the channel. Hey, thank you, Mitchell. Thank you for the informative content. Thank you, Mitchell. Thanks for subbing up, my man. We appreciate it. Impeach the judge. What could Trump do about getting overruled by rogue judges? Well, Congress could pass legislation to just say Trump can do these things and the judges can eat it. And I mean, even if that's the case, though, they still issue the nationwide injunctions. So Congress could impeach the judges, would be the ideal factor. But it's unlikely that they're going to do that. So it's a bit of a predicament, right? I think public pressure is going to be a lot on this. The more the public gets upset with the Supreme Court and the courts, the more I think that they're going to be forced into acting in accordance with the populace. But it's an uphill battle. This is the reason why the Supreme Court and the court in general is looked at with so much skepticism. And for a long time, the Supreme Court was like a redheaded stepchild in American government. To be clear about this, the Supreme Court didn't even get their building until 1935. They were like an afterthought in many ways. They didn't start their nationwide injunctions until the 1960s. And so their power was necessarily limited, and they are gobbling it up in these last decades. Nationwide injunctions, and now they're essentially in control of foreign policy out of the courts. Totally inappropriate, reprehensible, and they need pressure from the public to call them out on that. That's exactly what we're doing here. So thanks for being a part of that, Mitchell. We appreciate you. All right, my friends, amazing comments. Thank you for sending those in. I mean, it is gross. But it's Denny's gross, okay? It's like Denny's gross. So you just have to, as long as you accept, like you're going to have, it's like going to Vegas, all right? It's like you're going to Vegas. Like you know what you're going to get. You're going to Denny's. There's a reason you're going there. You know what you're going to get. It's not like organic Whole Foods, but it's Denny's. And man, when it hits, it hits. What's up, Sandy? Says the people in power want the violent criminals. Their purpose is to be warriors in the front, controlling the population by criminal behavior, while the rulers have a safety net to do more evil upon them. You have to fight the violent criminals before you can take out the criminal rulers. Yeah, it's like their Praetorian Guard, so to speak. You keep the peasants so bogged down with criminality. They live in their high estates in Washington, D.C., away from the consequences of the populace. And everything is just gravy for them, miserable for us. And they can just keep going on. We're not playing that game anymore. All right. Like we can see the distinctions. They don't care about COVID citizens filing claims, but they care about illegal gangbangers. Ridiculous. Hey, Jen Griffin, what's up on X? Glad someone called SCOTUS out. It's about time. I watched Trump call the president of South Africa while at my surgeon's office. Trump was diabolical. I'm here for it. Good to see you, Jen. Jen Griffin, Mini Tika. Good to see you, Mini Tika. Says, shreddings, warnings, and rulings. Hit the like button and follow us on Rumble. Wow, that shooting is on YouTube, huh? Fred Pedamonte shared that. Family demands answers after deadly officer-involved shooting on YouTube. Brian Allmark says, Judge Ho for the win. I know, seriously, that was great. And Retired Dave says, God bless Judge Ho. Someone needs to call SCOTUS out, and he was brilliant and absolutely accurate. It was really, really nice to see. Good stuff. Jack in the Box, too, curly fries. A lot of those during college. I remember. And the tacos, man. And the tacos. Yeah. Like 30 tacos, drive through 30 tacos with your bros. How many? We'll have 30 tacos. Okay, please pull forward. We'll have them out in 2 minutes for you. All right, thanks. All right, so my friends, what a beautiful day and a beautiful stream it has been. Very glad and grateful to have you here and to be able to go through this stuff with you. An honor and a treat and a privilege. Diane, you don't need to know, says, can we petition loud demand immunity revoked? 4 months as a member. Thank you, Diane. Bean, Carrie B, John, Janek, Dog Digger, all of our mod friends, we're grateful for you. Thank you for modding the fort down for us and keeping everything nice and orderly around here. We are going to pause there for the evening. We're going to reboot. We're going to have an after party here for a few minutes and debrief on the day. YouTube friends, come on back and join us. Go to the main channel homepage, hit refresh in about 2-3 minutes. We'll see you and we'll debrief on our members only after party. Locals, friends, don't move a muscle. The stream will continue shortly. But my friends, it has been a beautiful day. Happy Wednesday, all downhill from here. We're coming back tomorrow. We're going to get into it again. And until then, I hope you're having a beautiful night. But when we come back tomorrow, we are going to need to see you right back here so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.